Yeah, you better do that.
Authority. I hope you can't hear the noise here in the background because.
Yeah, I need to share my screen.
Yeah, stand by. I am just letting people in and hosting privileges, co-host. Okay, there you go.
Can I share my screen? Okay, let's have a look. All right, that's looking good.
Okay.
Excellent.
Okay, that's all working. Good.
Can you see the weather in London? It is absolutely chucking it.
Is it? Oh no.
And the guys, they've got these guys on ropes cleaning, the sort of.
Oh God, yeah.
Today of all days, they picked today of all days to be sailing down the side of this building. It is absolutely chucking it down.
Well, it better stop doing that before next week, anyway.
All right. Well, should we rock and roll, Sabina?
I think we'll rock and roll. We're recording anyway. A couple of people are just trying to connect.
Excellent.
And apologize for the background noise. My dog is making confetti.
That's all right. Well, as long as he doesn't eat any sheep, that's okay.
Well, he can't eat sheep in here, but he's eating role play scenarios at the moment. So
brilliant. Excellent.
Boston's role play scenarios. So that's
check out the guy in the back. Yeah, he's going to get wet today.
He is.
Okay.
Good stuff.
Do we do this?
We shall indeed. You start talking. I'm going to keep letting people in.
Brilliant. Okie doke. Well, good morning, good evening, good afternoon, wherever you are in the world. But I think the most of you are coming to us from sunny Ireland and not rainy London. Welcome to the 4th spotlight on mediation. Sabina, we're on a great streak here.
Absolutely.
We keep showing up every month. And if you are, or whether you're new to this spotlight series, whether you're a repeat offender, this is what we are going to cover on this power half hour on mediation. We've got a spotlight on the law, which is giving you some insights into the latest legal and regulatory landscape in Ireland. We've got a spotlight on the practice, where we peel the layers back to look at some skills, tools, tips, or strategies that might be useful to you. And lastly, we put a spotlight on one of our experts, and they will share with you an insight from their practice that you can hopefully take away and be inspired or do something differently and be just a better human being. So that's what we've got in store. I'm going to hand over to my partner in crime, the ever capable Sabina Walsh. Sabina, do a little bit of housekeeping, would you please?
Yes, I'll do housekeeping that doesn't involve picking up what my dog has just shredded all over the floor. Okay, so we're going to keep it nice and tight. So if you have any questions, comments, additions, if you put them in the chat box, and we will deal with them at the end. Okay. So I think we'll dive straight in, really. And our first little segment today is we're going to update you on a recent case which wasn't specifically focused on mediation, but had an interesting and concerning, from my perspective, mediation angle.
Oh, go on.
And those of you that hail from this part of the world probably heard about this one. It did get a little bit of coverage in the newspaper. So this was a sexual harassment claim in the Workplace Relations Commission, and we spoke about the increase in cases being referred to mediation through the WRC on the last webinar. But this was I think it's safe to say, unusual situation. That's a very benign way of putting it, where It was a courier company, and a female employee was subjected to some fairly unpleasant actions by her male colleague, who, when she came into a room with other male colleagues in it and had both her hands full, he, believe it or not, attempted to pull down her trousers, and then proceeded.
What planet? What
Yeah,
planet?
what planet, exactly. And then proceeded to kind of reenact it for the benefit of other female employees afterwards. Unsurprisingly, I suppose and now it did transpire when you dig into the background a bit that there had been other incidents with this particular chap. But anyway, the employee took a sexual harassment claim to the WRC, to the Workplace Relations Commission. And well, first of all, she complained to the company, and the company assured her that it would be fully investigated. Okay. And this is actually what gave rise to the claim then against the company, because the offender, for want of a better description, resigned in the interim, and the investigation was somewhat lacking, let's say. So the claimant then went to the WRC and took a sexual harassment claim against the company. Go on, Alan, have you a question?
So the guy that actually perpetrated this act just sort of got away scot-free.
He left. He exited stage left before any action could be taken against him. The company appointed their own accountant to investigate, which obviously raised some questions around the impartiality. But anyway, the investigation was never really completed. Nothing really happened. So the claimant found herself with no option but to go to the WRC. Whereupon basically it transpired the WRC found not only overwhelmingly in her favor, but awarded her the maximum amount of compensation permissible, on the basis that the company had, they failed at every level. First of all, they couldn't prove they had ever given her an employee handbook with a grievance procedure. When they did produce such a procedure, it actually referred to ACAS, which is a British workplace conciliation service and doesn't operate in Ireland. In fact, when it came to the WRC hearing, the accountant who allegedly did the investigation left halfway through the hearing because it was taking too long, which is what he said. So the whole thing was kind of shoddy. But why are we talking about this in the context of mediation?
Exactly. That was my question.
That was your question. Sorry, I beat you to it. The reason we are talking about it in the context of mediation is that one of the defenses put forward by the solicitor for the company, now not the company itself, who obviously don't have a good track record of, being sensible about these things, but the solicitor for the company argued that the claimant hadn't fully followed the grievance procedure, including going to mediation. And that it was her failure to follow that grievance procedure, including going to mediation, that prevented them from fully carrying out their investigation.
Going to mediation, that's bonkers.
It is bonkers, yeah. But this is this is the thing. It all sounds bizarre, but the lesson, or not the lesson, the concern that this raises is something that, if you're keeping a close eye on case law here in Ireland, is increasingly obvious, is that mediation, or the failure to try mediation, is being used in a kind of a scattergun way as a defense to absolutely everything. It's the unintended consequence of provisions around penalties for failure to mediate. So you're increasingly seeing arguments being made that the opposite party should have mediated, and therefore it's okay for us not to investigate, or not to prosecute the case, or not to do whatever. And clearly it shows either a lack or an utter disregard on the part of the lawyer who ordered this for the actual nature of mediation and situations when it may or may not be appropriate, as was found by the adjudicating officer in this case, who said, and I quote, "Given the allegation of a serious sexual assault, it was, in my view, a bizarre suggestion by the respondent that she should have mediated." So fortunately, the AO knew what he or she were talking about anyway, when it comes to mediation. But what it means for practice, I suppose, is particularly for lawyers, for solicitors and barristers, is to really, it's good now. There's been a change in that barristers and solicitors now are aware of the obligation to mediate, an obligation maybe to suggest mediation. But that doesn't mean now that it should be used, certainly not as a defense in every case, and that some degree of awareness around appropriateness for mediation still seems to be lacking on the part of some legal practitioners. Okay. There was also a slightly peculiar argument made around the fact that if the claimant had been actually issued with this handbook, which they weren't able to prove that she had, the obligation to go to mediation would have been an implied term of her employment contract, which is also a kind of a new one, and completely flies in the face of the voluntary nature of mediation. So, things that I think maybe we in the mediation education space, particularly for lawyers, need to work harder on is digging into the debate around what is and isn't suitable for mediation, and when is a suggestion or referral to mediation suitable. Secondly, what actually is law and practice around unreasonable refusal to mediate, and how is voluntariness preserved in that? And thirdly is, just kind of understanding how those questions might vary according to individual circumstances. So whenever we think we've kind of made huge strides in Ireland in relation to mediation awareness, something like this comes along and reminds you that actually there might be a little bit of a way to go. So it's an interesting one to watch, and watch out for if, as a mediator, you are being referred cases around by maybe legal professionals who feel that the case ought to go to mediation to protect themselves.
This is further upstream the problem, right? Where Correct. You've got solicitors who have to try and apply some kind of diagnostic Correct. Framework or some kind of criteria to determine whether a mediation a case is suitable.
Correct.
Is there a sort of a categorical framework, or is it a little bit sort of like a little bit of shades of grey?
Well, like most things in mediation, there are always a few shades of grey, and I think any of you that are working in mediation will know how assessing suitability for mediation can actually be quite a challenging and a complex task. That doesn't mean that there isn't guidance out there, or there isn't guidance you can rely on. There are various mediators. I mean, Rick Weiler springs to mind, have created a sort of mediation suitability checklists.
Okay.
Which at least prompt you to ask certain questions. But and questions is really your biggest tool. So if you want to jump to the next slide, Alan.
Yeah, all right. So this is quickly turning into the Sabina Walsh show, but I'm happy.
Sorry.
I can go with that. So
I'm always at my bossiest at 8 o'clock in the morning.
So I guess the focus here is for solicitors who need to be able to identify whether a dispute is suitable or not for mediation. And we're focused here, by the way, just on commercial disputes, because family disputes, that's a whole other kind of procedural pit of vipers. But let's move on to the next slide. And I guess then, if there isn't a sort of a definitive framework for determining whether a case is suitable for mediation, there is a way of being able to accomplish that through the kinds of questions or framework, sort of spectacles that you put on. You can look at the dispute and conduct some kind of sort of layer one analysis. Talk us a little bit through that.
Yeah, and this is, I mean, yes, it's for solicitors who are kind of triaging cases in the first instance. They're like the first person who sees you when you come into A&E and decides whether you need to go straight to the ER or not. But this is also important for mediators because, again, as I think possibly that case illustrates, just because a case gets you in mediation doesn't necessarily mean it's suitable. And in civil and commercial and possibly kind of employment cases as well, I think there's 3 layers of different factors. And the first series of questions you might ask is around the dispute. And, a big one there is around whether urgent relief might be required. Does somebody need an injunction? Is something going to happen in the next couple of days? And I mean, unfortunately, we've seen a couple of instances of that in relation to the cervical check scandal recently, where mediation was just suggested too late. Yeah. Does everyone have all the information? One of the, again, unintended consequences of the obligation on lawyers to refer to mediation at an early instance is that sometimes cases aren't suitable. In medical negligence, for example, the medical reports might not be available yet, and the damages may not have crystallized sufficiently.
Gotcha. Okay.
And then are the issues themselves suitable? I mean, I've had a couple of mediations bomb in midstream because someone has suddenly said, well, I can prove that you forged the will. Or, made a threat along the lines of, well, if you don't agree to this, I'm going to disclose this.
Yeah. Okay. So timing is a feature there. Obviously, I mean, if you can't mediate a personal injury dispute if they haven't had the accident yet. So
there is that. Then we also have questions around the parties. Okay. And what I mean there by limits is, do the parties really understand the limitations of the process? So are the parties happy to be in a dispute where it's up to them to come up with the solution? Or, as is often the case in sort of quite high level commercial cases, are they maybe looking for a bit more evaluation or direction? So as a mediator, you need to know where the limits of your role are, depending on what area and what style of mediation you practice. But you need to be clear that the parties are really signed up to the self-determination piece as well, which is sometimes not as straightforward as you would think.
Yeah. Okay. All right. So it's as Bruce Lee said, the art of mediating without mediating.
Yes, precisely. Exactly. You also want to make sure they don't have any concerns about the process that are going to prevent them from engaging in it, and that they have all the information. I mean, many's a mediation has fallen down on or never got out of the starting blocks on account of discovery not being complete, or one side not accepting the other side's information without additional orders from the court.
Right. Okay.
And then we get slightly into the more relational stuff, which even in a commercial dispute is important.
Okay.
I would want to be, and this is a lot of what Rick Byler actually focuses on in his checklist, is whether the parties have had for example, commercial relationship in the past, and whether that has been beneficial, whether there are benefits to them having a future relationship, or whether, for example, this is the termination of a partnership. I've mediated a lot of termination of legal law firm partnerships, and whether the desire there is really never to have anything to do with each other again, and very importantly, what the power balance is in the relationship. And something we're going to come back to in a future webinar, which is something I've been doing a little bit of work on just in the last few days, is around the state as litigant and the state as party in mediation, and perceptions of power when individuals are litigating or mediating in a case with the state as litigant. So watch this space, because there's some interesting research emerging on that at the moment.
Yeah, brilliant.
But the reason I raise that is around ensuring that both parties come to the mediation with as equal a power balance as is possible, or at least not one that is so great that it can't be modulated, shall we say, in mediation.
Yeah, okay. Just a small comment. I mean, you talked about future webinar. I feel like these are more like shows than webinars. Like, so
that's because we do so much talking, we don't let everyone else talk.
I think show sounds much better. Anyway,
yeah. Okay.
All right. So that's really helpful. So we've got questions around that are focused on the dispute, questions that are focused on the parties, do they have enough information, etc. As distinct from the relationship between them. You know, what's the relationship been like in the past? Where's it heading? Is there any, are they reliant on each other for financial or other sort of...
Correct.
Okay, that's...
Right.
I guess we're only scratching the surface here, Sabina.
Absolutely. I mean, as those of you who are mediating will know, it's not just kind of shades of grey, but actually suitability for mediation can change even as parties go to mediation, as the mediation begins. Factors might emerge, dynamics might change, the relationship might change, or the desired outcomes might reveal themselves to be so different that actually the case isn't suitable. So it's really incumbent on all of us, from those who are referring parties to mediation in the first instance to those who are actually engaged to mediate, to always kind of keep an eye on the suitability of the situation and the parties.
So whoever invented mediation and talked about it being a flexible process, they really mean it, right?
Yeah.
It's like flexible all the way.
Absolutely. And I think our expert piece is going to give a very nice little illustration of that. Brilliant.
Okay. All right. So this is my my little segment. I feel I've got a, I need to step up
your game here. Absolutely.
We've been doing all the heavy lifting as always. But whether you decide to use mediation, if you're a solicitor, as a shield or a stick, it's important that you establish the suitability. But some people use mediation as a wand, like a magic wand, because it can have like magical outcomes. And our next segment is the spotlight on the expert. And for this segment, we have gone to the well yet again and chosen a video with the mighty Geoffrey, although to his pals, Geoff Sharp from New Zealand. Geoff's a top-flight commercial mediator from Maxwell Mediations in Singapore. Geoff does usually sort of million and billion dollar mediations. There's such a thing as a $1 billion mediation. It's bonkers, isn't it? So he's a hugely experienced mediator. And but in this video, Geoff is talking about one of his commercial mediations that had quite a magical outcome. So we're going to leave you with this little video for a little sort of a dose of inspiration and sort of just feel good to set you on your way for the day. So the volume is up. Sit back and enjoy this 3 minutes of magic.
Well, there are plenty of process models, and I think good mediators will get up in the morning and say to themselves, what's my job today? So I think once we get into a sort of a default routine, that's dangerous. And look, a lot of mediations do follow the same pathway, but I think one has to, on the way to the mediation, say, what's my role today? Am I a convener? In other words, are the parties going to do it themselves, but I'm sort of just there to provide the room and a bit of oil?
Yeah.
Or am I really going to have to gain their trust, work on, you know, the reality testing of their position, etc., etc. So, you know, who knows? But the most unusual mediation I ever had was a combination of mediation and really a religious ceremony.
Wow.
And I spoke before about doing at one end of my practice historic sexual abuse mediations, and I find them really challenging in a whole different way than $1 billion dispute might be. But we were mediating with a you know 50, 60-year-old victim who had been abused as a child and a young adult, and we were mediating between her and the church in whose care she had been. And the bishop was there, and we did the usual stuff in a mediation. And his aim was to make reparation and, as he said, bring her back to the family of the church. And she hadn't been to church since she was a teenager because she couldn't physically stomach being in church because of what had happened. And they, towards the end of the mediation, took themselves off to a corner of the lawyer's conference room, you know, 30 floors up, shiny, big conference room, very corporate, and he administered communion. So left all the suits sitting at the table, and it was incredibly moving. We all had tears in our eyes, and she took the sacrament, and that was not part of the mediation, but it was the most important pivot in the mediation. And then there was an agreement that she would come to church in 3 months' time and meet her local vicar. You know, wonderful, wonderful result. And I think that is an example of how creative mediation can be in that context.
And how flexible the process can be.
Flexible, yeah, it was perfectly spontaneous. No one had sort of said, now, I will give you money if you take communion. It was, would you like me? And he pulled out a lovely silver box with the wafers.
Yeah.
It was just once in a lifetime for a mediator, once in a lifetime experience.
What a lovely story.
Yeah, and you go home, as a mediator, you go home and saying, well, I did something good today. Yeah. So it's wonderful. So, you know, I suppose my point is it can be as creative as you want. It can be, mediation can be in an aeroplane, you know, in a boat.
Yeah.
Such an inspiring story from Geoff there, and
such a great guy.
Yeah, and I think it goes to show as well, you know, you can go into mediation not really knowing where it's going, and maybe on the surface it doesn't look suitable for mediation, but it turns out it is, or maybe it is suitable for mediation. You get into the mediation and it turns out something else manifests that no one had expected, and as you said there, it's a flexible but magical process. So that's the end of our Power Half Hour. It's 8:29. I feel like we've actually gone through quite a bit in this 30 minutes. Hopefully, if you've been watching or listening, you found it useful. Just a few things. If you have found it useful, register for the next one, which is on Tuesday, July the 25th, again, 8 a.m.
Height of the holidays.
We will send you out a registration link by email, and it would be super if you'd be willing to share that with any of your network if you think others would find this useful. We have a newsletter which also goes out once a month with a slightly different flavor to this, and you can sign up for that at mediateacademy.com. And lastly, we have a Dublin Mediation Summer School, which is our commercial mediation 5-day training program running from the 31st of July to the 4th of August. In person, there's a little bit of online stuff to do before then. but we'll be convening in Dublin 7 and spending 5 days of intensive skill practice. If you are interested, get in touch, information on the website. If you know anyone that might be interested, then please do share information about the program with them. And I think
just to add to that quickly, and also you get the bank holiday to recover afterwards, which is always good. I want to do a little quick shout out to Tina, who's joined us from the States, because I've just processed what time it must be over there. I hope, Tina, you're on the West Coast and therefore it's only midnight or after midnight and not, in fact, 4 o'clock in the morning. And Lisa, yes, the Mediation Act and mediators proposals, that is something on the list to come back to at some stage, another hot potato. And that I have seen used in some interesting contexts. So yeah, as I say, watch this space and we'll come back to that one. All right. 4 a.m. powered up, Tina. We are impressed. We thought we were good being here and coherent for 8 a.m. 4 a.m. is a whole other ball game. That's fantastic. Level. It's lovely to meet you. And yes, the recording will be available in just so you can watch it again in case 4 a.m. really was a little bit too ambitious. So enjoy the sunshine or the rain wherever you are. Thanks for tuning in.
Have a great day, everyone.